Daniel, for that. Let us listen to some of the issues that were prosecuted by the judges.
In our context, and an amendment to transfer judicial authority from the judiciary and independent tribunals to the executive is to unmake the Constitution, as it fundamentally alters a central feature of the Constitution. While the Constitution does not fix the exact composition of IEBC and only provides a range of not less than 3 and not more than 9, statute fixes the composition to be 7. None of the parties suggest that national statute on the composition of IEBC is unconstitutional. Given its important constitutional mandate, IEBC should carry out its functions with all hands on deck. To allow the quorum of the Commission to oscillate with the actual number of members at any time would be to countenance a possibility that for as long as the numbers do not fall below 3, then the appointing authority need not promptly or at all trigger the process of filling the vacancies. The membership of IEBC could then suffer want of gender parity or regional or ethnic diversity that is required by Article 254.
In my view, it is not correct to elevate judges to the status of demigods, and just as it is possible to have a distrustful and rogue parliament, it is also possible to have a rogue and distrustful judiciary, more so bearing in mind that the latter are not elected as the people's representative. I am therefore of the persuasion that the contest of what is amendable and what is not should not be left to be a matter of judicial innovation. Judges, just like parliamentarians, cannot assume supremacy over all others, as indeed it is the people who are sovereign.
I am therefore in agreement with the High Court that there is a legal requirement under Article 10 of the Constitution for voters to be supplied with adequate information to make informed decisions. There is no evidence that that was done in this case. I still hold, therefore, and agree with the pronouncement by the High Court in the present case that the President can be sued in his personal capacity during his tenure because the protection afforded under Article 143(3) of the Constitution extends, quote, anything done or not done in the exercise of his power under the Constitution.
From my reading of the literature on these subjects, I am fully fortified in my view, which coincides with that of the learned judges, that a popular initiative is a citizen-conceived, citizen-initiated, and citizen-driven process. And these are the ordinary mwananchi. If the initiative is born of presidential fiat, no matter how well-intentioned, it ceases to be a popular initiative and must be recognized and named a state or presidential initiative. Now, the President's role in the conception and initiation of the Building Bridges initiative is writ large, and with it, the panoply of power and prestige of his office. First was the handshake, then the BBI Gazette, which was appointed by task force was appointed by Gazette, which is an official government publication. The task force prepared a report which it presented to the President as President and Commander-in-Chief. Moreover, the President again appointed the steering committee on the implementation of the BBI report by way of a special issue of the Kenya Gazette. Their report was presented to the President at a state lodge. That everything about the process bore the imprimatur of state involvement. It was a presidential government project, and this was wholly antithetical to the popular initiative.
On to held matters now, and the government has